Preparations for public inquiries. This presentation is aimed at the new operator or any operator wishing to understand why their operator license is at stake. Every operator should therefore be preparing for a potential public inquiry because it could be just around the corner, triggered by a roadside encounter, a fleet check, an overload, a driver not complying with the driver's hours rules, or some other incident that blindsides you on a Tuesday afternoon or has been brewing for some time, for example, a pending prosecution, perhaps not even directly related to the road transport operation itself. All these situations place your operation under the scrutiny of the regulator and may lead ultimately to a traffic commissioner reviewing your fitness to hold an operator license. So how do you prepare now? Well, for starters, read your license and the general or specific conditions it contains. Are you complying with your license obligations? Watch our presentations on operator licensing compliance. Are there any shortcomings in the way in which you organise your maintenance? Seek an external audit from an experienced transport consultant. Be proactive and, above all, understand that a compliant operator will translate into being an efficient operator with fewer problems and issues arising along the way. Being called to a public inquiry is a stressful experience for operators. The traffic commissioners have the power to suspend, curtail, and revoke operator licenses, which means the license and therefore the business is at stake. Occasionally, public inquiries are called due to a misapprehension by the Office of the Traffic Commissioner that, once understood, will lead to no further action being taken by the Traffic Commissioner. For the most part, in the majority of cases where operators are called to inquiry, there is usually some justification and some underlying cause. The underlying cause may stem from a lack of appreciation on the part of the operator of their obligations. It's akin to trying to assemble furniture from a flat pack without looking at the instructions first. Sometimes the instructions may be confusing, so it may take a degree of effort to work things out. When making an application for an operator license, the applicant submits to a number of undertakings. These are essentially promises from the operator to the traffic commissioner to undertake a series of actions, including keeping the vehicles and trailers in a fit and serviceable condition, observing the laws relating to drivers' hours, prompt reporting of defects found on vehicles, not exceeding the number of vehicles specified at each operating centre, and only using authorised operating centres in any traffic area, prompt notification of convictions and any other material change to the circumstances of the operation, which are to be notified to the Traffic Commissioner within 28 days. This, for example, can be as simple as a change in maintenance provider. The keeping of records for at least 15 months. These undertakings or promises seem straightforward enough, but they need a little bit of unpacking, because many operators called to inquiries have failed to undertake these promises. In many cases, this is down to a lack of appreciation as to what these promises entail. In other presentations, we discuss these issues and explain what the operator must do to ensure compliance. If any undertaking is broken, it is likely the operator will be called to a public inquiry. At a public inquiry, when deciding the outcome for the operator, the traffic commissioners will perform a balancing exercise and will weigh up the positive and negative features of the case and then make their decision. This means traffic commissioners will consider what has happened in the past and what steps have now been taken to rectify the issues. Were the steps initiated prior to the date of the call-up letter, or was there a last-minute flurry of activity generated by the call-up letter rather than a long-term desire to strive for compliance? Clearly, if you're reacting and responding to a call-up letter, then it's going to look very much a last-minute response, and that isn't going to impress the traffic commissioner. That said, the traffic commissioner will take into account anything that you have done, proactively or reactively, and the fact that you've left it late won't necessarily be fatal, but it won't be as impressive in the mind of the traffic commissioner than if you had striven to comply well before the call-up letter was issued. For the best outcome, operators should use the time available to make their best possible case and show compliance with the regulations prior to the date of the public inquiry. We advise the following steps are taken when preparing for the hearing. Firstly, the call-up letter advises operators to identify competent legal or professional help and representation. So, unless you're very confident and feel you don't need professional assistance, this should be your first consideration. Don't leave instructing your solicitor until the last minute. Then, understand the issues as they are presented in the call-up papers. This is essential so that any issues raised in the call-up letter can be identified and tackled and rectified. You should then implement and evidence the compliance systems introduced to rectify these shortcomings. You should decide whether training is required for your drivers, your transport manager, or even the directors, who may, through a lack of knowledge, have allowed things to fall into disarray. Directors need to understand the systems that need to be in place, and their lack of knowledge may be viewed by the Traffic Commissioner as being a contributing factor towards why things haven't been as they should be. Where there is a range of issues to rectify, an audit by a competent transport consultant and the implementation of that consultant's recommendations is obviously advisable. Always respond to correspondence from the Office of the Traffic Commissioner in a timely and courteous manner, as your responses will be seen by the Traffic Commissioner and they will be taken into account. To avoid any adverse inferences being drawn against you, the operator, always adhere to the timetable set out in the call-up letter and make sure that your finances are submitted on time and that all submissions and evidence you wish to present to the Traffic Commissioner are submitted well in advance of the public inquiry. By preparing effectively for the public inquiry, you are more likely to achieve a proportionate and favourable outcome. Failure to prepare is preparing to fail. But remember what was said at the very beginning of this presentation: prepare now. Don't wait for a call-up letter. You probably don't think you're ever going to get a call-up letter, and you probably think that you've got it sorted and there is nothing you can learn and there is nothing that you need to do to make your operation more compliant. Don't fall into that false sense of security. Make sure your house is in order now and thereby ensure the outcome of any future public inquiry is going to be as favourable as possible. We hope this short presentation has been helpful. Please like this presentation or leave your comments. Please subscribe to this channel and encourage your drivers and managers to do likewise. When you subscribe, you are automatically alerted when we add new presentations to our channel. It may well be that if you are ever called to a public inquiry, you might want to make reference to this subscription as evidence of the proactive steps you took to ensure compliance with your operator licence undertakings.